Hello, my name is Jerry, and I'll be explaining the law that is relevant for someone deciding the appropriate business structure for a small business startup, why the law is relevant, and I'll also include an explanation of the information that I require from the client to give advice and make a recommendation on the appropriate business structure for them. Now, to start, a small business startup would not be allowed to incorporate as an association structure, as Section 5, subsection 1C of the Associations Incorporation Act of 1981 of Queensland explains associations are not eligible for incorporation for the purpose of financial gain. Now, associations to me generally used for non-profit associations, for football clubs or a community legal centre. I think it's safe to assume that the whole point of a business startup of a small business is to make a profit. As such, I'm not going to go into any further detail on associations here. The business structure of a sole trader, however, is very easy to maintain and cheap to set up, costing $37 according to the Australian Taxation Office website. Termination and disbanding is straightforward, as well as restructuring the business. The term refers to an individual person conducting business without any benefit of any legal structure. There's no statutory provisions or regulations such as formation or termination because you're trading under your own name. As such, the sole trader is personally responsible for all internal and external debts and liabilities without any limitation, and this also stretches to employees of the business. Therefore, it's considered high risk due to the risk of losing personal assets, which is including jointly owned property with someone not a party to the business if your business was to fail. Vidaz Queensland Building Services Authority, Vidaz went bankrupt, but he was actually still personally liable to pay back all the debts. However, he also had to fight not to have his construction license revoked because not following your obligations accordingly under a sole trader can lead to licenses to trade being revoked that you actually need for your qualifications and profession. Section 6 of the Partnership Act of 1891 Queensland provides the rules for deciding the existence of a partnership, which are the business must be carried out by persons in common with a view to profit. Therefore, it's imperative to ask the client how many people will be involved in the business. Partnerships are not overly expensive to set up, and they can use a trading business name, combine resources and expertise of a number of different people, and are fairly simple to administer and restructure. Profits and losses are shared between the partners according to each person's share and is specified hopefully in the signed partnership agreement that everyone signed before they started conducting business together. Section 12, subsection 1 of the Partnership Act of Queensland strictly says that each partner is individually liable for all debts incurred by the other partners. There is unlimited liability jointly and severally, internally and externally on the partners, even if someone dies, because then the liability will then become an obligation of the deceased partner's estate. Practically, if a partner to a partnership was to go bankrupt, the other partners will need to pay out all the bankrupt partners' debts and liabilities if they want to carry on with the partnership business. Section 8 of the Partnership Act says that every partner acting on behalf of the business can bind the business to an agreement, and this is where it gets dangerous because all partners have a right to make decisions to participate in the management of the partnership, and this is why partnerships are the highest risk of the client's options because all partners are liable for any negligent acts, not only of themselves, but all of the other partners involved in the partnership, because everyone's authorised to make those binding decisions. So this can be where personal differences severely impact business. Dixon J actually affirmed this in Birchnell and Equity Trustees Executors Agency Ltd. Now, partners cannot transfer ownership to someone outside the partnership unless agreed by all of the partners. Section 28 of the Partnership Act disallows the expulsion of a partner by the majority unless under an express agreement to do so. The dissolution of a partnership requires paperwork and a notice to all of the other partners. So under Section 29 of the Act, there will be no agreement where there's no agreement that the partnership will end. The partner must give notice of their intention to leave in writing to all of the other partners. Now, Section 124 of the Corporations Act 2001 creates legal status over a company of that of an individual person. The individual directors are protected from liability and only the company assets can be recovered. If a company is unable to pay its creditors, there is no risk to the personal owner's assets. The advantage of shareholders is that they can only lose the value of their shares and are not liable for the company's debts. The company itself is like a sole trader, but the people behind the company are shielded from liability and are not directly liable for the obligations of the company. So everyone has limited liability unless pierced by the corporate veil, which very rarely happens, as per Solomon's case, which set this high standard of liability. And this is also why the company structure is an attractive and a key difference from the other structures. In the case of Lee & Lee's Air Farming Ltd, the court held that the main shareholder and governing director of the company is still a separate person. Makura and Northern Assurance Co. Ltd decided that shareholders have no legal equitable interest in the property of the company. So this means that essentially all insurances have to be in the company name, not that of any director or individual. This structure also ensures management and ownership will continue in the event of the death of the director or injury of the director, because shares can be transferred under Section 444 GA, subsection 1 of the Corporations Act. The running of a company is left up to the board. As such, shareholders don't need to be an expert to invest in the business under Section 189, subsection 1 of the Corporations Act. And you can also have one or more director or shareholder under Section 201A, subsection 1 of the Act. So there's two key differences to companies. One's a proprietary limited company, one's a public company. But I think the public company, it's unlikely for a small business would want to raise or borrow public money and sell their shares on the stock exchange. All companies are governed by Australian Securities and Investment Commission, ASIC, which administers the Corporations Act accordingly under Section 5B of the Corporations Act. There's still some downsides. They're heavily regulated with rules governing and setting up the company being very complex and high in cost. I know accounting firms charge roughly $1,200 to set a company up, and that's not including the other ASIC reporting requirements. So for these reasons, it's difficult to change or terminate a business structure. To terminate a company under ASIC, all the members must agree to deregister, must not be carrying on the business, the assets must be worth less than $1,000, there can be no outstanding debts or liabilities or any legal proceedings. And if this criteria is not met for voluntary deregistration under ASIC, you need to wind up the company, which can cost you more. Obviously, financial institutions and other companies know about the limited liabilities of companies, so usually they're reluctant to, enter into contracts or give you a loan unless the directors or shareholders provide personal guarantees as securities, as was seen in the case of Macquarie Bank and Lynn. So as such, company directors are not completely free from personal liability. However, they are more protected than that of partnerships or sole traders, but there is a big catch here to the limited liability of a company. So everything I've just explained is relevant because it lays out the legal rules for the different business structures, and depending on what the client wants, one of these is almost certain to apply.